Hi friends, Joe from the Clear Law Office, Oshkosh Elder Law Estate Planning, here with a tutorial for the Wisconsin State Statutory forms for your powers of attorney and your advance directives. How you can get them and just some tips and strategies for how to complete them. This is going to be very rudimentary, not going to go into great detail about what you should or should not do with these forms. To get more information, more detailed information, you should visit with an elder law attorney and walk through it with him or her. So let's start at the beginning. And here's the beginning right here. It is Google. So if you want to find these forms, they're available through the Wisconsin Department of Health Services. Here's how you have to find them. And this will work, I know, for Google. I can't say for Bing or Yahoo or anything like that, but definitely Google. So you got to type in is WIDHSADV. You see it populates with the advanced directives right there, but if you just hit enter, WIDHSADV, as you'll see right here, the first, and it's always the first link, is the one that we want. It's the forms for the advanced directives through DHS. So these are the forms that you will need for your powers of attorney. What you have here is your declaration to physician. That's your living will. We'll walk through that. Power of attorney for health care. This link right here is in English. You can get it in Hmong, Spanish, and Vietnamese as well. Power of attorney for finances. We're going to do that. I'm going to skip this authorization for final disposition. That would be for after you pass on, you want to give authority to somebody who can take you to the funeral parlor. That's automatically, if you don't have one of these, it's going to be your next of kin. But if you want to designate somebody else, you could fill out this form, but we're not going to bother with that today. So we're going to walk through the first ones, though, the living will, power of attorney for health care, and power of attorney for finances. All these populate as PDFs. So as you can see, you can download them, you can print them, no charge. So if you're an adult and you don't have these, the best thing you can do is to visit an elder law attorney. But if you don't have the time, or you just decide that you're not going to do that, then this will get the job done for the most part. So this is your living will. It starts off with, it explains the directions up here. This is about when you want feeding tubes or other life-sustaining procedures to be halted. You're in the hospital, and under what circumstances do you want to have those procedures to stop? The big things to bear in mind are the terms terminal condition. You're dying and the doctors agree there's no hope for you. Or persistent vegetative state. You're in a coma and the doctors agree you're never going to wake up. If you're not in one of those two, this is not going to apply. This only comes into play in one of those two situations. So, as you'll see right here, for this, and the same will be said for the healthcare power of attorney, you need two witnesses. You're going to sign this, and you need to do so in the presence of two witnesses. The witnesses cannot be related to you. They cannot have a stake in your estate, and they cannot be the medical providers or staff who are currently providing health care for you. If you have a neighbor who's a doctor or a nurse, but you don't see them for health care purposes, they're just your neighbor, they could serve as your witness. But you're an actual nurse at the hospital that you're at, they could not. There's a couple of exceptions. Chaplains or social workers, through their health care provider, they can serve as witnesses. But for the most part, you just want them to be as independent as possible. All right, so you have instructions. You got definitions of various terms. Hi, Nick. And some more instructions about when is this going to take place, what's the effect of signing this, and liability, waiving all liability for people who are relying on this. All right, so you go through the first two pages, and then on the third page is when you're actually going to start filling it out. So Oh God, here comes another email. Who's it going to be? Hope it's not embarrassing. And you write your name right up here. Just your name is necessary. You don't need to have any other contact information. Write your full name, print it out. And then you have 3 areas where you can check yes or no. First one, you have a terminal condition. So what's a terminal condition? We look back up here in the definitions. An incurable condition caused by injury or illness that reasonable medical judgment finds would cause death imminently, so that the application of life-sustaining procedures serves only to postpone the moment of death. All right, if you have been diagnosed with a terminal condition and you cannot state your own wishes, you don't have the capacity to do so. So this one's regarding feeding tubes. You can check, yes, I want feeding tubes used, or no, I do not want feeding tubes used. You check yes or no. If you do not check either box, they will be used. Persistent vegetative state, you know what that is. Coma, you're not going to wake up. And here you have 2 things to consider. Feeding tube down here. Do you want feeding tubes? Yes. You don't want feeding tubes? No. Life-sustaining procedures. So that's different than feeding tubes, and I think they're right here. Assistance in respiration, artificial maintenance of blood pressure and heart rate, blood transfusion, kidney dialysis, and the list goes on. So not feeding tubes, but they don't bother with that for terminal conditions because you're already on the way out. So life-sustaining procedures, do you want that if you're in a coma and you're never going to wake up? Check yes or no here. Again, for all, just like the first one, for all of these, if you don't check anything, they're going to give them to you, or at least that's where they're going to assume that that's what your wishes are. I'm going to get into the healthcare power of attorney, and I'll talk about that in a little bit, how that relates to these wishes. All right, and then that's it. You just have to sign it, but in the presence of 2 witnesses. Don't do this, and then run around and find some witnesses to say, here, this is my signature. You can do that on other documents, but just to be on the safe side, you wouldn't want to do that in this one. So you sign date, more identifiers, address, date of birth. Then your witnesses will sign date, print their name, both of them, same time, okay? Directives to attending physicians, you don't need to worry about that. Here you can list who you gave copies to, but that's optional. So that's the simplest one. Your living will. Just 4 pages, the last 2 are the only thing you have to worry about completing. All right, so you have that done. So let's back up here. Now let's go to the power of attorney for healthcare. A little bit more information is in here. Now the first 2 pages are just instructions, okay? They're not imperative to the actual document. There's another 6 pages that you have to have. First 2 pages are just instructions. Feel free to read through them if you want to. I'm just going to kind of explain the details as we go through this. The next 6 pages are what's important. Right now, this is the notice to a person making the document. You have to have this. If you don't have this completed by an attorney, and the attorney signs off saying, I explained everything sufficiently to the individual, then you have to have this language. This is in the statute. So this is the first page. The notice to the person making this document explains to you exactly what you're doing and the authority you're giving. Now, it does say, this is important to know, that no health care may be given to you over your objection. Now, that would be necessarily, all right, if you have capacity, okay? If you have capacity, nobody can overrule you, no matter who they are. If it's your spouse, adult children, your doctor, they can't overrule you. You have capacity, you have the right to decide what to do. If you lose capacity, this is where this comes into play. So, we go to the first page where you start filling this in. It'll be the second page of the actual form, 4th page of this PDF. You fill out the date up here. Print your name, full name, and then you're also going to write your address and date of birth up here in this section right here. Print it. Black or blue ink. I don't think it has to be black. And then you're going to nominate who your primary health care agent is. All right, I hereby designate, print their name, address, and telephone number. Very, very important to have that information so if they have to be contacted in the event of an emergency. And then this form allows you to have one backup, and you should have at least one backup. Other forms, such that you get from your healthcare provider or through attorneys like myself, you could have more than one backup. This one only allows you to have one backup. So this means you should be cognizant of the goings-on of your primary agent and your backup. If you become aware that one of them would no longer be appropriate to be on this list, you should get a new one. If you had several backups, you might be able to say to yourself, convince yourself that, okay, well, I still got enough folks on there to be taken care of, even if one of the persons on my list is not going to be available, and I'm certain of this. But here, if one of them goes down, you're only left with one, get a new one. All right. So they cannot be co-agents for healthcare. One and then the other. You cannot have co-healthcare agents in this state, and that's a good idea. You want to have one authoritative voice who's going to be making your decisions for you when it comes down to crunch time. So you list who they are, and a quick tip about who you might want to consider. This should not be something that you consider lightly. But things you'll be looking for is somebody who knows you well enough to know what your healthcare desires would be if you can't communicate them. Who's got enough level head and the courage, I suppose, to carry out your wishes no matter how difficult they may be. And is my opinion, and the opinion of several others, that geography is pretty important. They don't have to live necessarily in your town, but in a relatively short drive so that in the event of an emergency, they can be by your side. Also, that they see you often enough to have an idea exactly what's going on with your health. Is there a decline that they may be missing because you are several states away? They only see you a couple times a year. I've talked to some healthcare professionals who say geography is not so important. It's fine. We can handle a lot of this stuff remotely, over the phone, over the internet, whatnot. It'd still be valid if your agent or backup agent lives on the West Coast, the East Coast, what have you. But it's my opinion that geography is kind of important. So I tell people if they're half hour away, that's fine. If they're an hour and a half away, that's fine. But if they are, 3 or 4 hours away, you might want to consider other options. People generally put their spouse first if they're married, if their spouse has capacity. Then you'd be looking to, if you have adult children, to consider them. Or other family members would be considered, close friends. But any more discussion, I would say, it's going to be on you. And if you want to discuss it further with more detail, I would say you schedule a meeting with an elder law attorney. All right, general statement of authorities granted. Basically everything. There's a couple of things you got to check down here, but basically everything, including what happens when you're on the way out. So when it comes down to the living will and the healthcare power of attorney, well, I'll get into that in a little bit. What it doesn't do is allow them to submit you into a psychiatric or mental facility. They cannot do that. They cannot say, and they cannot allow you to be experimented on. That could only come with a court order. You can't grant them that authority. They can't have that authority just through this document. All right. So when it comes down to long-term care, what authorities do they have? Well, right off the bat, they have the authority to put you in a long-term care facility for rehab purposes. You break your hip, you have some surgery, they say you're going to need about a month or so of rehab. They can put you into a nursing home for that purpose. But only for short stays for rehab purposes. If you want them to be able to place you into a long-term care facility, whether it be a nursing home or a CBRF, community-based residential facility, that's an assisted living facility. If you want to give them that authority, you got to check yes here. If you don't want them to, you check no. Provision for feeding tube. Okay, do you want to give the ultimate say when it comes down to feeding tubes to your agent? You should. You should. It should be your agent who makes that final call rather than your living will. Your living will can serve as direct instruction to the healthcare provider, but I think it's best to have that to be to leave that to somebody in the family because, well, I mean, there could be some leeway there if the doctors all agree, no hope for this person, they're on their way out, but we can keep them alive and prolong the dying process. You may not want that, but maybe there are some people who want to come in and say their final goodbyes, and your agent would, be able to say, okay, let's hold off for a little bit to maybe a child is out of state and they want to come in and say goodbye and give them that opportunity. You can give them that authority. You should do so. Okay, healthcare decision for pregnant women. Okay, not my typical clientele. I do work with young families, but for the most part, most of my clients are obviously retired. So it doesn't come into play, but if you are a woman and you might become pregnant, you say, all right, do we give them full authority while I'm pregnant as well? Check yes or no. Statement of desires, special provisions, or limitations. Okay, here I'm going to say, what should you do in this? What should you write in here? Nothing without consulting with an attorney. Okay, this is, if you want to personalize this, do so only after speaking with a elder law attorney to make sure that it's a legally valid request and that it's not going to gum up anything else that you have in here. All right, so you have space to fill out your specific wishes and desires. Don't do it yourself. That'd be my recommendation. All right, this right here is a HIPAA release, essentially, saying that my agents can talk to the doctor, get all the records that they need to make the best choices. Okay, then we get to the signature page. Again, has to be signed by two independent witnesses, just like the just like the living will. So you sign and date it in the presence of these two independent witnesses. They're going to print their name, address, and they're going to sign it. Okay, now this last page here. Statement of healthcare agent and alternate healthcare agent. I understand that you designated me to be his or her healthcare agent, yada, yada, yada. Your name again, and then your agent and alternate agent can sign and write their address. Now, according to the statutes, this is optional. All right, it doesn't say optional. This section down here regarding anatomical gifts says optional. This right here, if they're around, if your agents are around, go ahead and have them sign it. Fine. It doesn't have to be contemporary with your signature. Where am I? All right. Where am I? There we are. Still hard to work with this. Doesn't have to be contemporary with your signature. Could be independent of that. But it's optional. According to the statutes, there's nothing in the statutes, chapter 155, saying that your agents have to sign this. But if they're around, might as well, just to make sure that all healthcare providers, that they don't take a look at this and say, something's missing. And that could delay their agent's ability to help you out. So I believe this is optional. Anatomical gifts, this is definitely optional. Do you wish to make anatomical gifts after you're gone? You could say, I wish to donate only the following organs. I wish to donate any organ. I wish to donate my body for anatomical study. Boy, this looks like this one should have had a check right here. I refuse to make any anatomical gift. Looks like there should have been a check mark here. If you refuse, I guess put a check next to here. There should be a check box there. That might be an error. If you fill out this section, make sure you sign and date it. If you don't, then it's you basically don't have any stated wishes, and it could hinder the ability for you to make anatomical gifts if you want to. It's optional, but you can specify it right here. All right, once it's signed and witnessed, then you're good. You should take this document along with your living will to your doctor, to your doctor's office. And when you check in at the front desk, give these documents to the person working the front desk saying, here are my new legal documents for health care, and they'll scan them and upload them network-wide, so they'd be available there. There's some information here as how you can file these, was register and probate, $8 a piece. I've never seen anybody do that. Never heard of it. Keep a copy for yourself. Give a copy to your primary agent, and give a copy to your healthcare provider. So those are the healthcare documents. One more document, and it's a big one, power of attorney for finances and property. Everyone should do this. It could be a big, big, big hindrance of your family's ability to help you, even your spouse's ability to help you if you lose capacity and you don't have one of these. So your spouse doesn't have the ability just to control all your finances unless you give authority. The law does not presume that you get along with your spouse. So if you want to fill this out, first page, instructions again. Starting with the second page is the official form starts. Recording area, you don't need to worry about this. This would be for if you're going to be filing it with the Register and Deeds, because you could file this with the Register and Deeds, and I guess it would be concerning a item of property. I've never filled that out. Never seen anybody fill it out. So you're going to start working on page 2 of the form, which is page 3 of the PDF. Name of the principal, that's you. You print your name, and right away you name your agent. Name of agent, agent's address, agent's phone number. Okay? You print it. All right? You can have successor agents. Here you have a chance for 2 successor agents. Now, they are presumed to be working, all your agents are going to be presumed to be working consecutively, one at a time. With your power of attorney for finances, this one right here, you can actually have them work collaboratively. Either, say, the first 2 or the second 2 or all 3. I wouldn't do that, but you could. But you'd have to do so in a special instructions section. I'll show you that later. So you have a chance to put up your primary and then 2 backups. So quick tips, how are you going to pick these? Here I would say definitely geography is not that big of a deal. They got to be an adult. They got to be in the country. But other than that, you pick somebody who's responsible, who's good with paying bills, taking care of their own assets, who is available, who could take on the load of caring for your finances and your property. So if it's somebody who's working 80 hours a week and has a family to go home to, maybe not them. But spouses, if you're married and your spouse has capacity, is generally number 1. Then you'd be looking at adult children, most likely, friends, siblings. Somebody that you trust, obviously, because you're giving them authority here to handle some valuable assets. And somebody that knows you well enough that they can continue on what would be your method of handling your assets. Because this could be for a long time. This could be for a week in the hospital, or it could be for several years where you're needing assistance. So if they're going to be doing that and they want to continue on as you would, whether it be liberally, conservatively, when it comes down to investing, you want them to do it as you would, so someone who kind of knows you well enough so that they'd be able to do that. So who are they going to be? You fill that out right there. Any more instructions, I would say, regarding who to pick, talk with an attorney. Grant of general authority. Now you have a list of things that you can give authority over. There's not a blanket, one more, they can handle all my assets and property, finances and property. You would go through here and initial, not check, not mark an X, initial every item that you would want your agent to have authority over. Now then, you may say, well, these are very, very broad, right? Real estate. So I'm giving authority over real estate. What does that mean? Fortunately, if you scroll down or flip the page down, the last 7 or 8 pages is the appendix, straight out of the statutes, and explains what does it mean. Okay? There's very little wiggle room in these. So you look through here and you decide you want your agent to have the authorities that are detailed in the last 7 or 8 pages of this PDF. And if you want them to have that authority to help you out in that respect, you initial. So you initial each box you want them to have. I would presumptively say if this is going to be your one power of attorney, I would recommend initialing all of them. Do not limit your agent. If you're going to have one agent who's going to be helping you out in the time of incapacity, you want to give them the ability to help you out as widely as possible. But I would not say anything further without consulting with an attorney. You know, if you come in and talk with me or talk with somebody else and you have more doubts, then we can discuss it further. All right, limitations. The general limitation. An agent who is not my spouse or domestic partner may not use my property to benefit the agent or a person to whom the agent owes an obligation of support unless I have included that authority in the special instructions. All right, well, so benefit the agent or benefit anybody, because what's not in here? Gifts. Okay? The ability to make gifts. It's not listed in here. You can't just sign off on that. Sometimes that's important. Sometimes you want that, either to continue a pattern of gifting to family, friends, or charity. Or gifting is a part of a strategy when it comes to long-term care planning. That's not in there. So just checking that off, your agent would not really be able to help you much when it comes to long-term care planning. Special instructions. You may give special instructions that can expand on these, can limit those, can give more authorities to your agent. Do not try to fill this out without the help of an attorney. Don't do it. Okay? Again, what you might write might not be legal, and it might gunk up the system for something else. Don't do that. Bring it before an attorney and you can talk about your options, about what you want to do, and get the wording right. Effective date. The power of attorney is effective immediately. You don't have to be declared incapacitated unless stated otherwise up here. It could be changed to a springing power of attorney, which means you have to be declared incapacitated by 2 physicians in order for this to carry any weight. I like immediately effective no matter what. If you can trust your agent well enough that you will give them full authority when you are out and you can't monitor them, why wouldn't you trust them to help you out when you are up and about and you can monitor them? Besides, this gives you the ability to delegate authorities. So if you still have capacity but you want help in this area or that area, be it taxes or tending to certain properties, then immediately effective is what you're going to need. Nomination of guardian. This is an optional provision. Now, if you are in need of a guardian appointed by a court, now ideally we have these documents here so we avoid the whole guardianship proceeding. But if you are in need of a guardian anyway, for whatever reason, you can nominate who you want your guardian of your state, which is pretty much the same thing as this power of attorney, and guardian of your person, which is pretty much the same thing as your healthcare power of attorney. You can list them to be the same persons you nominate as agents in these documents or different people. I don't know why you would have them be different people. Okay. So this page is where we left off. This is just where you sign. Should have recognized that from the start. So, this does not need to be witnessed. Has to be notarized, though. So, you got to do it in front of a notary. Go to your bank. UPS stores have notaries as well. Do not sign it in advance. Sign it in front of the notary. So you can fill out these portions here. These 3 lines right here. Beforehand. You print your name, put your address, put your telephone number, then you sign and date it. And the notary, they fill out the rest of the stuff here. And then you have a valid and executed and active power of attorney for finances. That stops. So page 4 of the document, right, of the actual form, once you get to that, you're good. Now the rest of the stuff is optional, and it's for your agents. This gives you, the agent can read this in terms of what their duties and responsibilities are as the acting agent. They can sign this saying, okay, fine, I'll do this. They don't have to. It's not necessary. You don't have to include this portion of it at all. Agent certification as to the validity of the power of attorney for finances. This is another bit that the agent can fill out. I've never seen it used. I've never seen it asked for. It does not need to be filled out or signed at the same time that you fill this out. If they are ever going to do it, they can just print it out and sign it independently. If some institution requires this, they can do that at when necessary. So that gets to page 7, and then the rest is just the definitions. So, yeah, lengthy document, 15 pages when you print it all out. 14 of those are the actual power of attorney, but you really only have to concern yourself with, of those 14 pages, pages 2 through 4. That's where you're either going to be filling out, initialing, or signing and having notarized. Once you have that done, you are set. So, as I said, these are immediately effective, and that's a good thing. You got to do this. You got to do this because if you ever lose capacity due to cognitive decline, we'll say, you'd be leaving your family members in a tough spot if you don't do this. You want to avoid the guardianship procedures whenever possible. They're a pain, they take a while, they cost a lot of money. So I used to rail against these documents, said they were no good. I think they're good. They're good. They're not as good as the type that I print out, or most elder law attorneys I would think would be able to produce, but 1,000 times better than not having anything. So you fill these out. You can give a copy to your agent, but you don't have to. Just make sure that they're in a safe space. You have these updated every couple of years, every 2 or 3 years probably, no longer than 5, absolutely. Even if you change nothing else, you want everything to stay the same, you are going to want to have a new signature date and a new notary, okay? Some institutions, they don't want to see old documents. If we're in Florida, I would say we get one every year. But here, every 2 or 3 years probably would be okay. It can vary from institution to institution. Okay, so that's that. That's the tutorial. Very long one. If you watch the whole thing, then you're in a good spot. So if you want to schedule an appointment with me, as you know, to discuss this further, you know my first appointments are always free. So everybody take care out there. Have a good day.